Hello everybody, I'm delighted to be with you today for this webinar to discuss the Hong Kong Exchange's consultation paper on the listing regime for overseas issuers, which was published on the 31st of March 2021. I'll begin today's webinar by looking at the Hong Kong Stock Exchange's proposals to simplify the listing regime for companies incorporated outside of Hong Kong and the PLC and introduce a single set of 14 shareholder protection standards that will apply to all Hong Kong Exchange listed companies, irrespective of their place of incorporation and the nature of their listing. The Hong Kong Exchange's listing rules apply to three categories of listed companies: companies incorporated in Hong Kong, companies incorporated in the PRC, and companies incorporated in neither Hong Kong nor the PRC, which are defined as overseas companies in the consultation paper. Throughout the webinar, I'll also be frequently making references to two rather long terms: grandfathered Greater China issuers and non-Greater China issuers. A grandfathered Greater China issuer is a company which has its centre of gravity in Greater China and is primary listed on one of three qualifying stock exchanges: the New York Stock Exchange, NASDAQ, or the premium segment of the main board of the London Stock Exchange, on or before 15th of December 2017 if it has an individual weighted voting rights structure, or 30th of October 2020 if it has a corporate weighted voting rights structure. A non-Greater China issuer is a company which is primarily listed on a qualifying exchange and does not have its centre of gravity in Greater China. The Hong Kong Exchange's overseas companies regime has developed significantly since it was first introduced in 1989, and currently has different requirements for companies incorporated in the four recognised jurisdictions, which are Hong Kong, the PRC, the Cayman Islands, Bermuda, and companies incorporated in acceptable jurisdictions, of which there are currently 28. A key development in the overseas companies regime was the publication of the SFC and Exchange's Joint Policy Statement on the listing of overseas companies in 2007, which was last updated on the 30th of April 2018. This provides guidance to overseas companies not incorporated in a recognised jurisdiction which wish to list on the Hong Kong Exchange. A key aspect is the guidance on how overseas companies can meet the listing requirements, which says that they must demonstrate that the laws of their jurisdiction of incorporation and their constitutional documents together provide shareholder protection standards that are at least equivalent to those of Hong Kong. This requirement is defined in the consultation paper as the equivalence requirement. Further updates to the overseas companies regime were made in 2018 with the adoption of Chapter 19C of the Listing Rules to facilitate the secondary listing of established innovative companies listed on a qualifying exchange. The Hong Kong Exchange recognises certain qualifying exchanges. These are the New York Stock Exchange, NASDAQ, and the premium listing segment of the main market of the London Stock Exchange. The addition of Chapter 19C was particularly significant as it allowed companies with a centre of gravity in Greater China to secondary list in Hong Kong for the first time, although the higher qualification criteria were imposed on these companies than on companies without a centre of gravity in Greater China. This was, though, a major development which paved the way for the secondary listings on the Hong Kong Exchange of some of China's most successful tech companies, including Alibaba, Baidu, JD.com, and NetEase. Moving on to the Hong Kong Exchange's proposals. The Hong Kong Exchange is proposing to simplify the listing requirements for companies incorporated outside Hong Kong and the PRC, that's overseas companies, by removing the current distinction between overseas companies incorporated in acceptable jurisdictions and those incorporated in recognised jurisdictions. However, the listing regime for companies incorporated in the PRC as joint stock companies, that's H-share issuers, will continue to be set out separately in Chapter 19A of the Listing Rules. Another key change proposed by the exchange is that all companies applying to list on the exchange, including Hong Kong and PRC companies and companies applying for secondary listing, should be required to demonstrate how they comply with a single set of 14 core shareholder protection standards. These will replace the existing shareholder protection standards set out in Chapter 19C and Appendices 3 and 13 of the Listing Rules and in the Joint Policy Statement. The Hong Kong Stock Exchange's objectives. These proposals are aimed at addressing two issues. First, the complexity of the requirements for listing overseas companies on the exchange, and secondly, the differences in the shareholder protection standards provided by companies incorporated in recognized jurisdictions and those incorporated in acceptable jurisdictions. Currently, the listing regime for overseas companies is fragmented, complex, and difficult to navigate, with the listing requirements set out in different places, including the listing rules, the joint policy statement, and various guidance letters. The Hong Kong Exchange is concerned that its requirements for listing overseas companies may be viewed as overly burdensome and unappealing to prospective listing applicants who are not familiar with them. As I mentioned, there are differences in the shareholder protection standards required of companies incorporated in recognized jurisdictions and those incorporated in acceptable jurisdictions. This is inconsistent with the Stock Exchange's objective of providing the same standards of shareholder protection to all investors. Companies incorporated in Bermuda and the Cayman Islands are regarded as meeting the equivalence requirement if they amend their constitutional documents in accordance with the relevant part of Appendix 13 of the Listing Rules. Parts A and B of Appendix 13 set out the shareholder protection standards the Exchange considers necessary to make up for the shortfalls in the shareholder protections provided by the company law of Bermuda and the Cayman Islands, as compared to Hong Kong company law. Overseas companies incorporated outside the recognized jurisdictions are required to satisfy the equivalence test by demonstrating that the laws and regulations of their jurisdiction of incorporation and constitutional documents together meet the standards of shareholder protection required by Section 1 of the Joint Policy Statement. As I touched on, the Exchange is proposing that all companies listed on the Hong Kong Exchange, irrespective of their place of incorporation and including secondary listed companies, will be required to comply with a single set of 14 core shareholder protection standards, or core standards, which will be set out in Appendix 3 to the Listing Rules. This will mean that the equivalence requirement will be repealed and the terms recognized jurisdictions and acceptable jurisdictions will no longer be used. The Hong Kong Exchange will not issue any new country guides, but will retain the existing country guides and may issue guidance on a case-by-case basis if novel issues arise in relation to the shares of a company incorporated in a new jurisdiction. The proposed core standards amalgamate the shareholder protection standards currently contained in Chapter 19C, Appendices 3 and 13 of the Listing Rules, and the Joint Policy Statement's key shareholder protection standards, except for those which the Hong Kong Exchange proposes to repeal, which are set out in Schedule C to the consultation paper. The proposed core standards cover fundamental shareholders' rights, including rights in relation to notice and conduct of shareholders' meetings, approval of important matters, the right to requisition a meeting, remove directors, vote, speak, and appoint proxies, corporate representatives, the appointment of directors to fill casual vacancies, and the inspection of the shareholders' register. If adopted, the core standards will apply to all companies that list on the Hong Kong Exchange, including Hong Kong companies and PRC companies. With respect to PRC companies, the consultation paper proposes that these companies will be required to comply with the detailed requirements in Chapter 19A of the Exchange's Listing Rules and Part D of Appendix 13 to the Hong Kong Exchange's Listing Rules, in addition to the core standards. Despite this, the Hong Kong Exchange is of the opinion that PRC companies will not be subject to undue compliance burdens, as the core standards are identical to the mandatory provisions for companies listing overseas and the Hong Kong Exchange's listing rules that PRC companies are already required to comply with, except for the core standard on the HKSCC's right to appoint proxies and corporate representatives. Appendix 3 to the Hong Kong Exchange's listing rules will codify the existing practice that all companies listing on the Hong Kong Stock Exchange will have to conform their constitutional documents to the core standards or demonstrate how the domestic laws and regulations to which they're subject and their constitutional documents taken together provide the core standards. As overseas companies will be required to notify the stock exchange if they're subject to any laws or regulations or provisions in their constitutional documents with respect to matters not covered by the core standards or the listing rules, which may be materially detrimental to the interests of the shareholders as a whole. The exchange will reserve the right to consider an overseas company to be unsuitable for listing in these cases. An overseas company listing on the Hong Kong Exchange will also be required to make certain disclosures in its listing document, which include disclosure of the major differences between the shareholder protection standards under its domestic laws and the core standards, and details of the measures that have been or will be put in place to address the differences, and the risk that the extent to which Hong Kong courts may be used as an avenue for aggrieved shareholders of non-Hong Kong companies is subject to limitations concerning, for example, the enforcement of a Hong Kong judgment against the overseas assets, operations and or directors of a non-Hong Kong company listed on the Hong Kong Exchange, and the enforcement of an overseas judgment in the Hong Kong courts. Overseas companies listed on the exchange will be required to monitor their compliance with the core standards on an ongoing basis and to inform the exchange of any material changes in the local laws or regulations which may affect their ability to comply with the core standards. Moving now to the proposed core standards. The first core standard proposed is a requirement that shareholders should have the power to remove any director, including a managing or executive director, by ordinary resolution, but without prejudice to any claim for damages under any contract. This standard is currently provided by Appendix 3 and Part B of Appendix 13 to the Listing Rules, except for a slight difference in the wording. The right will be stated to be the right of members rather than the issuer, as under the current Hong Kong Exchange Listing Rules, to make explicit that this is a shareholder's right. It is included because the exchange believes that shareholders' ability to remove a director by ordinary resolution is fundamental to shareholder protection and important for effective corporate governance. The consultation paper notes that a minority of grandfathered Greater China companies may need to amend their constitutional documents to comply with the standard. In the case of grandfathered Greater China companies and non-Greater China companies with non-compliant weighted voting rights structures allowed under the Hong Kong Exchange's listing rules, the right of non-weighted voting right shareholders to remove directors may undermine the effectiveness of the permitted weighted voting rights structure. A non-compliant weighted voting rights structure is one that doesn't meet with the requirements of Chapter 8A for primary listing applicants with weighted voting rights structures. Examples of non-compliance weighted voting rights structures include weighted voting rights structures with corporate weighting voting rights or a board-based weighted voting rights structure, which gives certain individuals control of the board, which is disproportionate to their equity stake in the company. These structures are permitted under Chapter 19C for grandfathered Greater China issuers, which are Greater China companies primary listed on one of the three qualifying exchanges on or before the 15th of December 2017, which secondary list on the exchange. In these cases, the exchange will assess the applicability of the standard to relevant companies on a case-by-case basis. The second core standard proposed is that any person appointed by the directors to fill a casual vacancy on the board will hold office only until the next AGM and will then be eligible for re-election. This standard is currently provided by Appendix 3 to the Listing Rules. Section 4625 of the Companies Ordinance provides that a vacancy created by the removal of a director can be filled by a casual vacancy, but does not stipulate that the appointed director will hold office only until the next AGM. The Hong Kong Exchange proposes to apply the core standard to all Hong Kong Exchange-listed companies to preserve shareholders' ability to elect directors after a casual vacancy arises. The consultation paper notes that a minority of grandfathered Greater China companies may need to amend their constitutional documents to comply with this standard. In the case of grandfathered Greater China companies and non-Greater China companies with non-compliant weighted voting rights structures allowed under the Hong Kong Exchange's listing rules, the permitted weighted voting rights structure may allow weighted voting right holders to appoint directors. The applicability of this standard to these companies will therefore be reviewed by the Exchange on a case-by-case basis. The Exchange proposes that if this standard is adopted, the comply or explain requirement on casual vacancy appointments in the Corporate Governance Code in Appendix 14 to the Listing Rules will be repealed. The third core standard proposed is a requirement that listed companies must hold an annual general meeting for each financial year. The Hong Kong Exchange is proposing to add a note that the AGM should generally be held within 6 months after the company's financial year end. This standard is based on the Hong Kong Companies Ordinance and the mandatory provisions applicable to PRC companies, Parts A and B of Appendix 13 to the Hong Kong Exchange's listing rules, and the Joint Policy Statement's key shareholder protection standards, which currently require the companies to which they apply to hold an AGM each year within 15 months of the previous AGM. Companies already listed on the Hong Kong Exchange, which are subject to this 15-month requirement, will be regarded as compliant with this core standard if they comply with the requirement that applied to them at listing. The next core standard proposed will require listed companies to give shareholders reasonable written notice of general meetings. The Hong Kong Exchange is proposing to add a note that reasonable written notice means at least 21 days for an annual general meeting and at least 14 days for other general meetings. Currently, there are different notice requirements for general meetings depending on where a company is incorporated. Companies incorporated in an acceptable jurisdiction are required to give reasonable notice of general meetings, but there is no specific time limit. This is also true for grandfathered Greater China issuers and non-Greater China issuers. The mandatory provisions which apply to PRC incorporated companies require 45 days notice of a general meeting, while the PRC company law requires 20 days notice of AGMs and 15 days notice for special general meetings. Cayman Islands and Bermuda incorporated companies are required to give 21 days notice of AGMs and 14 days notice of any other general meeting. Except for PRC companies on the Hong Kong Exchange, the Exchange is proposing that all listed companies will have to give at least 21 days notice for an AGM and at least 14 days notice for any other shareholders meeting. For PRC companies listed on the Exchange will consider 20 days notice for annual general meetings and 15 days notice for special general meetings acceptable. Companies which are currently listed on the Exchange, which have been allowed to list with a shorter notice period, will be considered to be in compliance with this proposed core standard, provided that they comply with the requirements which apply to them at the time of listing. If this proposed core standard is adopted, the comply or explain provision in the Corporate Governance Code, which requires 20 clear business days notice for an AGM, will be repealed. The next proposed core standard will extend to all Hong Kong Exchange-listed companies the right of shareholders to speak and vote at general meetings, except where shareholders is required by the listing rules to abstain from voting to approve the matter under consideration. Currently, only companies which are incorporated in an acceptable jurisdiction and grandfathered Greater China listed companies and non-Greater China listed companies provide shareholders with the right to speak and vote at a general meeting, which is analogous to the proposed core standard. In this regard, paragraph 34 of the Joint Policy Statement says that members must have the right to speak and vote at a shareholder meeting, except where a member is required by the listing rules to abstain from voting to approve the transaction or arrangement. For example, where the member has a material interest in the transaction or arrangement. Companies incorporated in the Cayman Islands, Bermuda, or Hong Kong are not under a similar obligation. Having said that, the Hong Kong Exchange explains that the right to speak and vote at general meetings is implied in the company's ordinance and in the mandatory provisions. In addition, the Corporate Governance Code requires that Hong Kong Exchange-listed companies ensure that the chairman attends general meetings to answer shareholders' questions, and that directors should also attend general meetings to get an understanding of shareholders' views. The Hong Kong Exchange therefore considers that there is an expectation in the listing rules that all listed companies should provide members with a right to speak. The proposed core standard will be applied to all Hong Kong Exchange-listed companies to align shareholder protection standards across all jurisdictions. The next core standard proposed will require that where any shareholder is required under the listing rules to abstain from voting on any particular resolution or restricted to voting only for or only against any particular resolution, any votes cast by or on behalf of such shareholder in contravention of such requirement or restriction must not be counted. This proposed core standard is currently included in Appendix 3 to the listing rules and is also a key shareholder protection standard under the Joint Policy Statement. The company's ordinance also contains a similar requirement. The Hong Kong Exchange considers this to be a fundamental shareholder protection and proposes to apply it to all companies listed on the Hong Kong Exchange. If a Hong Kong Exchange-listed company can demonstrate that it can achieve this core standard through an alternative means, for example, a two-tier voting arrangement, the Hong Kong Exchange may consider it to be in compliance with the core standard. The next proposed core standard will require that members holding a minority stake in the total number of issued shares must be able to convene an extraordinary general meeting and add resolutions to a meeting agenda. The minimum stake required to do so must be not higher than 10% of the voting rights on a one vote per share basis in the share capital of the issuer. Currently, under the Joint Policy Statement, which applies to companies incorporated in an acceptable jurisdiction and grandfathered Greater China issuers and non-Greater China issuers, the minimum level of members' support required to convene an extraordinary general meeting must be no higher than 10%. The company laws of Bermuda and the mandatory provisions applicable to PRC incorporated companies have equivalent provisions. The company laws of the Cayman Islands do not have an equivalent right to convene an extraordinary general meeting. However, the Exchange explains that Cayman Islands incorporated companies listed on the Exchange have incorporated the provision into their constitutional documents. Under the Hong Kong Companies Ordinance, shareholders representing 5% of the total voting rights of all members can request the directors to call a general meeting. The next core standard will require that variation of class rights will require the approval of a supermajority vote of the members of the class to which the rights apply. There is also currently a key shareholder protection standard, paragraph 34 of the Joint Policy Statement, to the effect which applies to companies incorporated in acceptable jurisdictions, grandfathered Greater China issuers, and non-Greater China issuers. However, there are inconsistencies with respect to the threshold required to vary class rights and the level of quorum required. Under the Joint Policy Statement, a supermajority requires a 2/3 majority vote to vary the class rights attached to any class of shares. but does not stipulate the level of quorum that is required. For grandfathered Greater China and non-Greater China issuers, Chapter 19C of the Listing Rules requires variation of class rights by a 2/3 majority of the members present and voting. For PRC incorporated companies, the mandatory provisions require a 2/3 majority vote of the shareholders that are present and have voting rights to amend class rights. For Cayman Islands and Bermuda incorporated companies, Appendix 13 to the Hong Kong Exchange's listing rules requires their constitutional documents to specify a 3/4 majority as the threshold required to vary class rights, which is in line with the proposed core standard. The Companies Ordinance similarly specifies a 3/4 majority. The Hong Kong Exchange proposes that a supermajority vote should mean at least 3/4 of the voting rights of the members holding shares in that class present and voting in person or by proxy. The Hong Kong Exchange is proposing to apply the proposed core standard to all Hong Kong Exchange-listed companies. However, for PRC incorporated companies, it's proposed that the current requirement under the mandatory provisions be maintained. For existing Hong Kong Exchange-listed companies which are currently subject to the JPS Key Shareholder Protection Standard, which defines a supermajority vote as a 2/3 majority, the Exchange does not intend to impose a higher threshold on these companies. These companies will be considered to be in compliance with the core standards if they satisfy the requirements that apply to them on listing and will not need to amend their constitutional documents to comply with the proposed core standard. The Hong Kong Exchange is also proposing a core standard that a supermajority vote will be required to approve amendments to the constitutional documents of an exchange-listed company. Similar to the inconsistencies I've just mentioned with regard to the threshold and quorum required to vary class rights of shareholders, there are inconsistencies with respect to the required threshold and quorum required to amend the constitutional documents of an exchange-listed company depending on its place of incorporation. The Hong Kong Exchange is proposing that the threshold for a supermajority vote should be a 3/4 majority of the voting rights of members present and voting in person or by proxy, so as to align it with the current requirements for companies incorporated in Bermuda, the Cayman Islands, and Hong Kong. The current requirements for PRC companies under the mandatory provisions require a 2/3 majority vote for amendments to the constitutional documents. These will be maintained. For existing Hong Kong Exchange-listed companies which are currently subject to the Joint Policy Statement's Key Shareholder Protection Standard requiring a 2/3 majority vote, the Exchange doesn't intend to impose a higher threshold on these companies. They will instead be considered to comply with the proposed core standard if they comply with the requirements which were applicable to them at the time of listing on the Hong Kong Exchange. The next proposed core standard is that the appointment, removal, and remuneration of auditors must be approved by a majority of the issuer's shareholders or another body that's independent of the board of directors. This proposed core standard is currently a key shareholder protection standard under the Joint Policy Statement, while the Companies Ordinance, Cap 622, and the mandatory provisions have equivalent protections. The company laws of Bermuda have similar provisions, except that 2/3 of the votes cast at a general meeting are required for the removal of an auditor, setting a higher threshold than the proposed core standard, which only requires a majority vote. The Cayman Islands company laws don't have such a requirement. So if this proposed core standard is adopted, companies incorporated in the Cayman Islands may need to amend their constitutional documents to ensure compliance, as the Hong Kong Exchange proposes that this core standard be applied to all Hong Kong Exchange-listed companies. The Hong Kong Exchange proposes to apply this core standard to all Hong Kong Exchange-listed companies. The Exchange is of the view that shareholders' power to approve the appointment, removal, and remuneration of an auditor is important for ensuring auditor independence and effective corporate governance. The next core standard will require that every member should be entitled to appoint a proxy who need not necessarily be a shareholder of the issuer, and that every shareholder, which is a corporation, should be entitled to appoint a representative to attend and vote at any general meeting of the listed company. Where a corporate shareholder appoints a representative, it should be treated as being present at the meeting in person. A corporation can execute a form of proxy under hand of a duly authorised officer. Currently, only companies incorporated in the Cayman Islands or in the PRC are subject to this requirement under the listing rules, although the company laws of Bermuda have equivalent provisions. This proposed core standard is also consistent with the Companies Ordinance, which allows a member of a company to appoint a proxy. Accordingly, companies incorporated in acceptable jurisdictions and grandfathered Greater China issuers and non-Greater China issuers may need to amend their constitutional documents to comply with this core standard. Importantly, the Exchange points out that they propose to expressly include in the proposed core standard that the appointed representative should be entitled to vote as well as attend any general meetings. This complements the proposed core standard in relation to the Hong Kong Securities Clearing Company Limited, that's HKSCC's, right to appoint proxies or corporate representatives, which I'll talk about in a minute, and is consistent with the proposed core standard that a shareholder of an exchange-listed company should have the right to both speak and vote at shareholder meetings. The Exchange is also proposing a core standard that the HKSCC must be entitled to appoint proxies or corporate representatives to attend the listed company's general meetings and creditors' meetings, and those proxies or corporate representatives must enjoy comparable rights with other shareholders, including the right to speak and vote. A note will be added to the core standard which will provide that where the laws of an overseas jurisdiction prohibit HKSCC from appointing proxies or corporate representatives with the rights described, the issuer must make the necessary arrangements with HKSCC to ensure that Hong Kong investors holding shares through HKSCC have the rights to vote, attend, personally or by proxy, and speak at general meetings. This standard currently applies to companies incorporated in Bermuda and the Cayman Islands under Appendix 13 to the listing rules. It's also a key shareholder protection standard under the joint policy statement applicable to issuers incorporated in acceptable jurisdictions, as well as non-Greater China issuers and grandfathered Greater China issuers. Although the listing rules don't currently require Hong Kong or PRC incorporated companies to comply with the shareholder protection standards, the Exchange explains that existing listed companies incorporated in these jurisdictions comply with this standard in practice. It's proposed that this core standard should be applied to all Hong Kong Exchange listed companies. The proposed core standards will also require listed companies to make the Hong Kong branch register of members open for inspection, although they may be permitted to close the register on terms comparable to Section 632 of the Hong Kong Companies Ordinance. Cayman Island incorporated companies are currently subject to the proposed core standard, while Hong Kong Companies Ordinance and the Companies Laws of Bermuda have equivalent provisions. This proposed core standard is not a key shareholder protection standard under the joint policy statement. The mandatory provisions applicable to PRC incorporated companies listed on the Hong Kong Exchange also provide for shareholders' rights to inspect the branch register. The Hong Kong Exchange proposes to apply this core standard to all Hong Kong Exchange listed companies. So companies already listed on the Hong Kong Exchange, which are incorporated in acceptable jurisdictions or are non-Greater China listed companies or grandfathered Greater China listed companies, may need to amend their constitutional documents to comply. The next core standard proposed will require a supermajority of the issuer's shareholders in a general meeting to approve a voluntary winding up of the listed company. There are currently different voting threshold requirements for a voluntary winding up. The joint policy statement and the mandatory provisions both require a 2/3 majority, whilst the Companies Winding Up and Miscellaneous Provisions Ordinance in Hong Kong requires a voluntary winding up to be passed by a special resolution. That's a resolution passed by at least 75% of the total voting rights of all members who vote on the resolution. Companies incorporated in Bermuda or the Cayman Islands are not currently subject to this shareholder protection standard. The Hong Kong Exchange proposes that a supermajority vote should mean at least 3/4 of the voting rights of the members present and voting in person or by proxy. This proposed core standard will apply to all Hong Kong Exchange-listed companies except those incorporated in the PRC. Instead, for PRC-incorporated companies listed on the Hong Kong Exchange, it's proposed that the current requirement for a 2/3 majority under the mandatory provisions should be retained. Additionally, for Hong Kong Exchange-listed companies which are subject to the HKEX shareholder protection standard, which requires a 2/3 majority vote, the Hong Kong Exchange does not propose a higher threshold, and these companies will be regarded as complying with the proposed core standard if they meet the requirement that applied to them at listing. Repeal of certain existing shareholder protection standards. The Hong Kong Exchange is proposing to repeal a number of the shareholder protections currently set out in Appendices 3 and 13 of the Listing Rules and the Joint Policy Statement, as set out in Schedule C to the Consultation paper. The provisions that will be repealed are considered by the Hong Kong Exchange to not concern fundamental shareholder rights. Application of the proposed core standards to existing Hong Kong Exchange-listed companies. Subject to the responses to the Consultation paper, it's proposed that the core standards will apply to companies already listed on the Hong Kong Exchange, as well as to new listing applicants, except where the Hong Kong Exchange has expressly stated that a proposed core standard will not apply to existing listed companies. As I mentioned when I went through the proposed core standards, the proposed 3/4 supermajority required for the variation of class rights, amendments to constitutional documents, and voluntary winding up will not apply to listed companies which are subject to a 2/3 majority requirement in relation to those matters under the Joint Policy Statement. Companies listed on the Hong Kong Exchange at the time the proposed core standards are implemented will have until their second AGM after implementation to make any necessary amendments to their constitutional documents to ensure compliance. With the proposed repeal of the Joint Policy Statement, the Exchange is proposing to codify some of its requirements. Probably the most important of these is the regulatory cooperation requirement. That's the requirement that in order for an overseas company to list on the Exchange, the statutory securities regulator in its jurisdiction of incorporation and its place of central management control, if that's different, must be a full signatory of the IOSCO Multilateral Memorandum of Understanding concerning consultation and cooperation and the exchange of information, that's the IOSCO MMOU, or have entered into an appropriate bilateral agreement with the SFC. The regulatory cooperation requirement doesn't currently apply to companies incorporated in Hong Kong, the PRC, Bermuda, or the Cayman Islands. However, the Hong Kong Exchange is proposing to apply the requirement to all companies listing on the Hong Kong Exchange by codifying it in Chapter 8 of the Main Board Rules and Chapter 11 of the GEM Rules. The aim is to facilitate SFC investigations and enforcement actions against all listed companies with core assets and operations offshore. Since no company from an acceptable jurisdiction has ever been accepted for listing on the basis of a bilateral agreement between the SFC and an overseas statutory securities regulator, the Exchange is also proposing to remove the reference to bilateral agreement and to codify its existing practice, which is to consider an exception to the requirement for the statutory securities regulation to be a full signatory of the IOSCO MMOU on a case-by-case basis. The Exchange is also proposing to codify in a new guidance letter several other provisions of the Joint Policy Statement. These include the guidance on alternative financial reporting standards and auditing standards, the Joint Policy Statement's requirement relating to company information sheets, is also proposed to be extended and codified in the listing rules. The requirement to publish a company information sheet on the Hong Kong Exchange's website and to update it for material changes currently applies to primary listing applicants not incorporated in a recognised jurisdiction and all secondary listing applicants. The Exchange is also proposing to require company information sheets for all secondary listed companies and for other overseas companies where the Exchange believes that the publication of a company information sheet would be useful to Hong Kong investors, for example, to provide them with information on overseas laws applicable to the company. The Exchange will also revise the listing rules to reflect the changes made to the Financial Reporting Council Ordinance to adopt a system of registration or recognition for audit firms which prepare auditors' reports or accountants' firms for listing applicants and listed companies. In summary, the proposed changes regarding the introduction of core standards are fairly extensive in that they will apply to all companies listing or already listed on the Hong Kong Exchange, including companies which are incorporated in Hong Kong and secondary listed companies. This means that companies already listed will need to look at their compliance with the core standards and, where necessary, amend their constitutional documents to ensure compliance. However, I'm not convinced that the changes will necessarily attract more international companies to list in Hong Kong. Companies incorporated in a jurisdiction which is new to listing will still have to show that their statutory securities regulator is a full signatory to the IOSCO MMOU and demonstrate compliance with the core shareholder protection standards. For the first company to list from a new jurisdiction, this is likely to be a time-consuming and expensive process. So turning now to the second half of the webinar, now I'm going to focus on the proposed changes to the requirements for secondary and dual primary listings of overseas companies. The Exchange is proposing to expand the secondary listing regime for overseas listed Greater China companies from traditional sectors. That's companies not meeting the definition of innovative companies as set out in the Exchange's guidance letter GL 9418, which do not have weighted voting rights structures, and to allow companies to dual primary list on the Hong Kong Exchange while maintaining their existing weighted voting rights structures and variable interest VIE structures. The first proposal would allow US and London-listed Greater China companies from traditional sectors to secondary list in Hong Kong with a significantly lower market cap requirement than currently applies under Chapter 19C. This would pave the way for smaller companies with their centres of gravity in Greater China to secondary list in Hong Kong. The proposal is likely to be attractive to US-listed Chinese companies which have been subject to increasing scrutiny and political pressure. In the context of dual primary listings on the Exchange, the consultation paper identifies two main issues. First, the current listing rules and guidance materials provide no clear guidance on the basis on which the Hong Kong Exchange will grant waivers to primary and dual primary listed companies. Secondly, grandfathered Greater China issuers and non-Greater China issuers cannot apply directly to the Exchange for a dual primary listing and retain their weighted voting rights structures that do not comply with the Chapter 8A requirements for weighted voting rights structures of primary listing applicants and or VIE structures that don't comply with the narrowly tailored requirements of the Hong Kong Exchange's listing decision 43.3. The listing rules allow overseas companies to apply for a primary or dual primary listing on the main board, or GEM, or for a secondary listing on the main board. Different listing rules apply depending on whether an overseas company is seeking a primary, dual primary, or secondary listing. Primary and dual primary listed companies typically have all or a majority of their equity securities traded on the Exchange and are required to fully comply with the listing rules unless specifically waived. A company with a dual primary listing has a primary listing on both the Hong Kong Exchange and an overseas exchange and is subject to the full requirements of the Hong Kong Exchange's listing rules and those of the overseas exchange on which its securities are also listed. A company with a secondary listing on the Hong Kong Exchange has a majority of its equity securities traded outside of Hong Kong, and the Hong Kong Exchange will grant the company extensive waivers from the listing rules through automatic waivers. This is because it's already subject to regulations and enforcement in the jurisdiction of its primary listing. The Hong Kong Exchange therefore requires that a secondary listing applicant demonstrate that its jurisdiction of incorporation and the market of its primary listing provide standards of shareholder protection that are at least equivalent to those of Hong Kong. The Hong Kong Exchange and the SFC have recognized 15 overseas stock exchanges as recognized stock exchanges, providing shareholder protection standards equivalent to those provided in Hong Kong. The appendix to the joint statement sets out 14 common waivers that are currently available to overseas companies applying for a dual primary listing on the exchange, subject to specified conditions, and a smaller number of common waivers that overseas companies seeking a primary listing on the exchange may apply for. The Hong Kong Exchange requires overseas companies applying to dual primary list on the exchange to submit a waiver application demonstrating their need for any common waivers applied for and their ability to meet the prescribed conditions. The Hong Kong Exchange considers each waiver application based on the company's particular circumstances. The Hong Kong Exchange determines whether to grant a common waiver based on the underlying principle that the overseas company must demonstrate that strict compliance with both the relevant Hong Kong Exchange listing rule and the overseas exchanges requirement would be unduly burdensome or unnecessary. Therefore, where the circumstances which supported the grant of an exemption or waiver of an overseas company no longer exist, for example, on its delisting from an overseas exchange, the Hong Kong Exchange has the discretion to revoke the exemption or waiver. Currently, neither the exchange's listing rules nor the joint policy statement set out the principles underlying the grant of common waivers, and the exchange hasn't published any guidance or codified the basis on which it will grant waivers to overseas companies applying for a primary or dual primary listing. Therefore, as part of its proposals to provide clear guidance on the basis on which the Hong Kong Exchange will grant waivers, the Hong Kong Exchange proposes to codify the underlying principle which requires that the overseas company must demonstrate that strict compliance with both the relevant Hong Kong Exchange listing rule and the overseas exchanges requirement would be unduly burdensome or unnecessary. It will also codify in proposed Hong Kong Exchange Listing Rule 1959 certain common waivers which are currently set out in the appendix to the joint policy statement, where the Hong Kong Exchange believes that the underpinning principle and conditions are unlikely to change in the foreseeable future. The Hong Kong Exchange will still require companies to apply for common waivers, and the Hong Kong Exchange will continue to grant common waivers on a case-by-case basis, subject to applicants demonstrating at a minimum that they meet the prescribed conditions. The Hong Kong Exchange is also proposing to allow grandfathered Greater China issuers and non-Greater China issuers with non-compliant weighted voting rights and/or VIE structures to dual primary list on the Hong Kong Exchange. At present, grandfathered Greater China issuers and non-Greater China issuers cannot apply for a dual primary listing on the exchange while retaining a non-compliant weighted voting rights and/or VIE structure. A non-compliant weighted voting rights structure is a weighted voting rights structure that does not meet the requirements for weighted voting rights structures under Chapter 8A of the Listing Rules and the Exchange's Guidance Letter 93/18, which sets out further requirements for weighted voting rights structured companies to be considered suitable for listing. A non-compliant VIE structure is a variable interest entity structure that doesn't meet the requirements for VIE structures under Listing Decision 43.3 as set out in Hong Kong Exchange's Guidance Letter 94/18. This is because all companies seeking a primary or dual primary listing on the exchange with a non-compliant weighted voting rights and/or VIE structure are required to amend these structures to satisfy the relevant requirements in order to list on the exchange. However, it's currently possible for grandfathered Greater China issuers and non-Greater China issuers to obtain a dual listing while retaining a non-compliant weighted voting right and/or VIE structure through a two-step route. Grandfathered Greater China issuers and non-Greater China issuers which secondary list on the exchange under Chapter 19C are exempt from Chapter 8A's requirements for weighted voting rights structures by virtue of Listing Rule 19C12 and for the requirements for VIE structures under the Exchange's Listing Decision 43.3. This means that grandfathered Greater China issuers and non-Greater China issuers can secondary list on the exchange while retaining a non-compliant weighted voting rights structure and/or VIE structure. If, following the secondary listing of a grandfathered Greater China issuer, the demand for its shares in Hong Kong increases and results in the majority of trading in its listed shares migrating to the exchange on a permanent basis, the company will be regarded as dual primary listed in Hong Kong and will lose the benefit of the automatic waivers granted to it. However, grandfathered Greater China issuers are allowed to retain their non-compliant weighted voting rights and/or VIE structures when a majority of trading in their shares migrates to Hong Kong, despite the fact that they are then regarded as having a dual primary listing on the exchange. Non-Greater China issuers are also able to retain their non-compliant weighted voting rights and VIE structures regardless of where trading in their shares occurs. This is because the trading migration requirement does not apply to non-Greater China issuers. The Hong Kong Exchange is therefore proposing that grandfathered Greater China issuers and non-Greater China issuers should be allowed to dual primary list directly on the exchange and be permitted to retain their non-compliant weighted voting rights and/or VIE structures. The Hong Kong Exchange doesn't consider this proposal to expand the concessions available to those companies, since the listing rules already allow those companies to become dual primary listed while retaining non-compliant weighted voting rights and/or VIE structures via the two-step route. However, these companies will be required to comply with the suitability and eligibility requirements of Chapter 19C, despite the fact that they are applying for a dual primary listing. They will also be subject to the full set of the listing rules, subject to any waivers granted by the Hong Kong Exchange. Even where a majority of the trading in their listed shares takes place outside Hong Kong, the Hong Kong Exchange will also reserve the right to reject an applicant on suitability grounds if its weighted voting rights structure represents an extreme case of non-conformance with governance norms. The listing rules and related guidance materials don't currently provide guidance on whether grandfathered Greater China issuers and non-Greater China issuers, which are secondary listed under Chapter 19C, can retain their non-compliant weighted voting rights and/or VIE structures if they delist from the qualifying exchange of their primary listing. The Hong Kong Exchange therefore proposes that grandfathered Greater China issuers and non-Greater China issuers will be allowed to retain their non-compliant weighted voting rights and/or VIE structures which are pre-existing at the time of their secondary listing or dual primary listing on the exchange if they are delisted from their qualifying exchange. However, these companies will still be subject to all the other exchange listing rule requirements unless specifically waived. When the listing application is made, the Hong Kong Exchange also has the right to reject the applicant on suitability grounds if its non-compliant weighted voting rights structure represents an extreme case of non-conformance with governance norms. For example, if the company has non-voting shares. What this means for grandfathered Greater China issuers and non-Greater China issuers which have non-compliant weighted voting rights and/or VIE structures that apply for a dual primary listing is that they will, provided the proposals are adopted, be assessed by the exchange in the same way as those applying for a secondary listing on the exchange. Moving on to the Hong Kong Exchange's proposals in relation to secondary listing, the consultation paper identifies a number of issues. First, the coexistence of two secondary listing regimes under the Joint Policy Statement and under Chapter 19C is considered confusing. Secondly, the requirements for secondary listing are more restrictive for companies with a centre of gravity in Greater China that for those with a centre of gravity outside Greater China. Thirdly, the Hong Kong Exchange's approach to granting waivers to secondary listing applicants is currently unclear. Lastly, the market is unclear as to whether automatic and other waivers granted to a secondary listed company will continue when the majority of trading in its shares migrates to the Hong Kong Exchange, or it delists from the overseas exchange on which it's primary listed. The Hong Kong Exchange is proposing to consolidate its requirements for secondary listings to reduce the complexity of the current regime. There are currently two routes to secondary listing on the exchange. The joint policy statement provides for the secondary listing of overseas companies that have a centre of gravity outside Greater China and can meet the additional eligibility requirements set out in Section 5 of the joint policy statement. Chapter 19C of the Listing Rules provides for the secondary listing of innovative companies that are listed on one or more of the three qualifying exchanges and can meet the suitability and additional eligibility requirements set out in Chapter 19C and related guidance materials. Companies are eligible for secondary listing under Chapter 19C whether or not they have a centre of gravity in Greater China, but companies with a centre of gravity in Greater China are only eligible for secondary listing under Chapter 19C. Companies with their centre of gravity in Greater China are not permitted to list under the joint policy statement due to the perceived regulatory risk that they may seek a secondary listing to avoid the full rigour of the primary listing requirements. The Hong Kong Exchange is proposing to consolidate the requirements for secondary listings in Chapter 19C of the Listing Rules. The revised chapter would include the secondary listing requirements currently set out in Chapter 19 and Section 5 of the Joint Policy Statement, with the amendments proposed in the consultation paper. The Exchange also proposes to consolidate the requirements for overseas companies' primary listing on the Hong Kong Exchange in Chapter 19. The proposed requirement for an applicant to be subject to the regulatory requirements of its market of primary listing. The Exchange is proposing to include in the Listing Rules a provision similar to that included in the Joint Policy Statement, that the Hong Kong Exchange has the right to refuse to list the shares of a secondary listing applicant which has received waivers from or is exempt from rules, regulations or legislation that result in it being subject to regulatory requirements that are materially less stringent than those which generally apply to entities listed on its primary market, for example, foreign private issuers in the US market. The proposed provision aims to ensure that the Hong Kong Exchange can rely on the regulatory regime of companies' primary listing market. To deal with concerns that companies with a centre of gravity in Greater China are subject to higher quantitative requirements for secondary listing, even if they don't have a weighted voting rights structure, the Hong Kong Exchange is proposing that all overseas companies without weighted voting rights structures, including those with a centre of gravity in Greater China, be allowed to seek a secondary listing and enjoy automatic waivers by meeting one of the two sets of quantitative eligibility requirements. Under Criteria A, a company will be eligible for secondary listing if it has a track record of good regulatory compliance of at least 5 full financial years on a qualifying exchange for an overseas company without a weighted voting rights structure, or on a recognised stock exchange for an overseas company without a weighted voting rights structure and without a centre of gravity in Greater China, and an expected market capitalisation at the time of secondary listing of at least 3 billion Hong Kong dollars. Under Criteria B, a company will be eligible for secondary listing if it has a track record of good regulatory compliance of at least 2 full financial years on a qualifying exchange and an expected market capitalisation at the time of secondary listing of at least 10 billion Hong Kong dollars. This proposal aims to consolidate the existing 2 routes to secondary listing by codifying the Joint Policy Statement's requirements for companies without weighted voting rights structures, Criteria A, alongside the requirements of Chapter 19C, that's Criteria B. The current requirements for profit, revenue and cash flow, would continue to apply to secondary listing applicants without weighted voting rights structures, as would the management continuity and ownership continuity requirements under the Exchange Listing Rule 805. Secondary listing applicants with weighted voting rights structures would not be affected by the proposed Criteria A and Criteria B eligibility requirements. They would instead need to satisfy the existing quantitative eligibility requirements under Chapter 19C. The Joint Policy Statement currently provides that the requirement for a track record of good regulatory compliance of at least 5 years on a recognised exchange, which is a condition for the grant of automatic waivers, doesn't apply if a secondary listing applicant is well established and has a market capitalisation that is significantly larger than the US $400 million. The Hong Kong Exchange is proposing to introduce a similar exemption and does not apply the listing compliance record requirement of either Criteria A or Criteria B to secondary listing applicants without a weighted voting rights structure on a case-by-case basis. If the applicant is well established and has a market capitalisation at listing that is significantly larger than the 10 billion, the minimum market cap required to secondary list under Criteria B. We've seen an increasing number of overseas listed companies with a centre of gravity in Greater China seeking homecoming secondary listing on the Hong Kong Exchange under Chapter 19C amid US-China tensions, with Hong Kong becoming an even more important capital raising venue, particularly for new economy companies. The successful listing of Alibaba in November 2019 in Hong Kong paved the way for a few that followed. In 2020, we saw NetEase and JD.com debut in Hong Kong. However, these companies which seek a homecoming face more restrictive requirements for secondary listing under Chapter 19C than companies with a centre of gravity outside Greater China. And the Hong Kong Exchange is concerned that the tighter restrictions under Chapter 19C for companies with a centre of gravity in Greater China, but without weighted voting rights structures, may be disproportionate to the level of risk these companies pose to investors. The factors relevant to determining whether a company has a centre of gravity in Greater China include whether or not the company has a listing in Greater China, the company's place of incorporation, its history, where the company is headquartered, and where it has its place of central management and control, the location of the company's main business operations and assets and corporate and tax registrations, and the nationality or country of residence of the company's management and controlling shareholders. To address these problems, the Hong Kong Exchange proposes to lower the minimum market cap thresholds for secondary listings of companies with a centre of gravity in Greater China. The proposed Criteria A would allow companies with a centre of gravity in Greater China to secondary list on the Hong Kong Exchange with a minimum market capitalisation at listing of at least 3 billion Hong Kong dollars if they have a track record of 5 full financial years of good regulatory compliance on a qualifying exchange. Companies with a centre of gravity in Greater China with a track record of 2 years good regulatory compliance on a qualifying exchange could secondary list under Criteria B if they have a minimum market cap at listing of at least 10 billion Hong Kong dollars. However, to avoid the risks of regulatory arbitrage, an application for the secondary listing of a company with a centre of gravity in Greater China, which is primarily listed on a recognised stock exchange, will be considered only in exceptional circumstances on the basis of the company's particular circumstances and the merits of the particular case. These proposals would allow more companies with a centre of gravity in Greater China to secondary list on the exchange. Chapter 19C only allows companies to secondary list if they're listed on a qualifying exchange and meet the exchange's definition of innovative company, even if they do not have a weighted voting rights structure. Since Chapter 19C provides the only route to secondary listing for companies with a centre of gravity in Greater China, the innovative company requirement prevents Greater China companies operating in traditional industries from secondary listing on the exchange. The exchange is therefore proposing to remove the innovative company requirement for secondary listing applicants without a weighted voting rights structure, including for companies with a centre of gravity in Greater China. The Hong Kong Exchange identified in the consultation paper certain risks associated with secondary listings, where the aim is to attempt to circumvent certain listing rules that apply to primary listings. To deter attempts at regulatory arbitrage, the Hong Kong Exchange proposes to introduce a listing rule giving the Hong Kong Exchange a discretion to reject a secondary listing application if it considers that the listing is an attempt to avoid the listing rules applicable to a primary listing. The Hong Kong Exchange is proposing to apply the test for a reverse takeover under Chapter 14 of the Hong Kong Exchange's listing rules to determine whether a transaction and/or arrangement or series of transactions or arrangements that the secondary listing applicant conducted before the proposed secondary listing constituted a reverse takeover of the listing applicant. If a material part of a secondary listing applicant's business was primary listed on the overseas exchange by way of a reverse takeover, the exchange will normally consider the application to constitute an attempt to avoid the listing rules applicable to a primary listing. According to the Hong Kong Stock Exchange's estimates, around 18 companies with a centre of gravity in Greater China that are listed on a qualifying exchange would have met the proposed lower market cap criteria and would have been eligible to apply for a secondary listing on the exchange as at the 29th of March 2021. The exchange considers that the proposed market cap requirements at listing of at least 3 billion Hong Kong dollars or 10 billion Hong Kong dollars and requirements for 5 or 2 years of good listing compliance will mitigate the risk of secondary listed companies coming to dominate the Hong Kong market. Greater China issuers secondary listed under Chapter 19C will lose the benefit of the automatic waivers if the majority of trading in their listed shares migrates permanently to the Hong Kong Exchange. This requirement only applies to Greater China issuers. To ensure consistency in the requirements, the exchange is proposing to extend this so-called trading migration requirement to all companies with a secondary listing on the exchange. The Hong Kong Exchange is proposing to codify the principles according to which the exchange will waive, modify, or grant exemptions from the listing rules for companies with or applying for a secondary listing. There are 4 principles. The first is reliance can be placed on the regulatory standards which apply to the overseas company offshore, including those of its jurisdiction of incorporation and the recognised exchange on which it has a primary listing, and on the enforcement of those regulatory standards by relevant regulatory authorities. The second is that regulatory cooperation agreements are in place between the SFC and the overseas company's jurisdiction of incorporation and its jurisdiction of primary listing, where they're different. The third is that a majority of the trading in the overseas company's shares doesn't take place on the exchange on a permanent basis. The fourth is that strict compliance with the listing rules would be unduly burdensome. The Hong Kong Exchange will reserve the right to revoke any specific or automatic waivers granted to a secondary listed company where any of these factors cease to apply. The Hong Kong Exchange proposes to codify in the listing rules the automatic waivers and certain common waivers in circumstances where the Hong Kong Exchange believes that the underpinning principle and conditions of these waivers are unlikely to change over time. The common waivers that will not be codified for secondary listed companies are the same as those which will not be codified for companies dual primary listed on the exchange. The Hong Kong Exchange is proposing to remove the condition for the waiver of the shareholders' consent requirement for a new issue, allotment, or grant of securities by a secondary listed company under the Hong Kong Exchange Listing Rule 1336. The requirements of Listing Rule 1336 can be waived for a secondary listed company which is not subject to any other statutory or other requirement giving shareholders pre-emptive rights over further issues of shares. The Hong Kong Exchange considers that a waiver by the Hong Kong Exchange of Listing Rule 1336 will not have a materially adverse effect on shareholders. This is because where the shareholders of a secondary listed company have preemptive rights outside the exchange's listing rules, the company will still have to offer securities to them first. In effect, the shareholders will still retain the right to participate in future share issues and protect themselves against possible dilution. The Hong Kong Exchange Listing Rule 1392 requires a listed company's nomination committee or board to have a policy on board diversity, which must be disclosed in the listed company's corporate governance report. When Chapter 19C was adopted, this requirement was a code provision under the Corporate Governance Code from which companies secondary listed under Chapter 19C were exempt. Since the provision has been upgraded to a listing rule requirement, which is not covered by the automatic waivers, the exchange has received requests for clarification as to whether secondary listed companies are still exempt from the requirement. The Hong Kong Exchange is proposing that all secondary listed companies should be required to have a policy on board diversity and to disclose it in their corporate governance reports. Finally, I'll now look briefly at the Hong Kong Exchange's proposals relating to delisting from an overseas exchange of primary listing and the disapplication of waivers in these circumstances. The listing rules are currently silent on the effect of automatic waivers and other waivers granted to a secondary listed company when a company is delisted from the overseas exchange on which it's primary listed. The Hong Kong Exchange proposes that in the event that a secondary listed company is delisted from the overseas exchange where it is primary listed, the Hong Kong Exchange will regard the company as having a primary listing on the Hong Kong Exchange. This will result in any automatic waivers and specific waivers that were granted to the company based on or conditional on its status as a secondary listed company ceasing to apply. The company will then have to comply with all the listing rules applicable to a primary listed company immediately upon its delisting from the overseas exchange of its primary listing, subject to any waivers and/or grace periods granted by the Hong Kong Exchange. The Hong Kong Exchange will require advance written notice from a secondary listed company where it plans to voluntarily delist from its primary listing exchange, or where it forms a reasonable expectation that it may be delisted involuntarily by a delisting notice. This delisting notice should be given as soon as practicable, and the exchange may request the provision of additional information. The Hong Kong Exchange will issue a written notice to the secondary listed company informing it that it will regard the company as having a primary listing on the Hong Kong Exchange on the occurrence of its delisting from its primary listing exchange. Where a secondary listed company wants to retain, following its delisting from the overseas exchange on which it's primary listed, any exemption or waiver that was previously granted or available to it, or wants to apply for a new waiver from any of the exchange's listing rules, it will be required to submit a waiver application to the exchange together with the delisting notice. The waiver application will need to contain sufficient information to demonstrate for the Hong Kong Exchange to grant the waivers and will be assessed on a case-by-case basis. It will issue its decision on the grant of the waivers applied for, including any grace period and conditions for granting the waivers, together with its notice informing the company that it will be regarded as primary listed on the exchange. Any grace period granted under a time relief waiver will commence from the time the company is delisted from the overseas exchange of its primary listing. As a general principle, a company that becomes primary listed on the exchange as a result of its delisting from the overseas exchange of its primary listing will be expected to use its best endeavours to comply with all the listing rules applicable to primary listed companies. With the exception of the financial reporting standards requirement, the exchange considers that a grace period will only be justified in limited circumstances. The exchange has pointed out that it will not normally grant any grace period for compliance with the Hong Kong Exchange's listing rules that are rarely waived for primary listed companies. Finally, a reminder that the deadline for responding to the consultation paper is the 31st of March 2021. Turning now to the Q&A, I think I have time for one quick question. Well, here's one. How many countries have signed the IOSCO MMOU? Well, at the current time, I think there's 124 countries which are full signatories to the IOSCO MMOU. But I would comment that this leaves a number of jurisdictions which, where if the central management and control of the company is in that jurisdiction, even if the company itself is incorporated somewhere else, they wouldn't be able to list. For example, there's a number of quite important resources jurisdictions where the countries have not signed, are not full signatories to the IOSCO MMOU. For example, the DRC, Ghana, Mozambique spring to mind. So it would continue to be very difficult to list mining or resources companies from those jurisdictions on the Hong Kong Stock Exchange. Well, unfortunately, we've now run out of time and there's no time for more Q&As. But if you have any questions, please send them to me at juliacharlton@charltonslaw.com and I will do my best to get back to you. So that brings us more or less to the end. Thank you again for joining me today. Please consider joining us for a further webinar on the 4th of June at 5 p.m. on the latest Hong Kong Exchange's consultation paper on corporate governance and board diversity. I do hope I'll see you then. Thank you. Bye.